Okay, we are live. Welcome to the first Game Lore Q&A. There's actually no one watching now, so I'm gonna wait a minute until people show up. Assuming that people will show up. Let's hope. Just gonna drink my coffee. My mug. Let me tweet about this. Let's try that. Links, hold on, event page. Tweet. Oh, there's two people watching. Hey, sorry, I was tweeting the link. Okay, well, let's get started then, since we have a couple people. Actually, can you guys let me know if you can see me and hear me okay? Actually, how do you do that? I guess you would put that in as a comment, right? I have no idea. Chat, there's a chat. Here we go. Sorry, this is my first time doing this, so might be a little bumpy in the beginning. So feel free to put something in the chat. There's a Q&A section over here that should allow you to ask questions. Oh, there we go. Actually, somebody put a question there. Perfect, Madison. All right, so I am going to go through my little spiel in the beginning, and then we'll get started answering questions, okay? Welcome to my first Game Lawyer Q&A. This is exciting. I'm probably gonna do one of these either every other week or maybe monthly. I've got some guests slated for the next few shows, developers, lawyers, other game lawyers, some game business people, analysts. So it's pretty exciting. So we'll be able to have questions come in, not just for a lawyer, but also other people in the industry. I think it's gonna be pretty cool. I'd also love to get some independent developers in maybe a roundtable discussion on here. I think that would be awesome. So if you're interested, please contact me. I'd love to talk to you. Let's talk about me real quick. So I used to be an animator and a designer on children's edutainment games back in the late 90s to the early 2000s. So now I'm a lawyer. I work mainly with independent developers in video games, mobile apps, and board game spaces. I'm also a digital nomad. So actually, currently, I'm in an office in Bangkok, Thailand. It's 8:40 in the AM right now. So hold on. Carl Schmidt, you don't see a chat. How do I start? There's a button on the left. There should be some sort of toolbar on the left, and there's a button at the top that says chat. It should be enabled. I wrote something in there. There should be a group chat going. All right. Oh, what did I hit? Showcase. Okay. Yeah. I'm currently in Bangkok, Thailand. Before this, I was in Tokyo. Before that, I was in a few different cities in China. I've been all around the US. It's exciting, but that's kind of why I like working with independent developers, because I'm kind of an indie myself. I don't have a big fancy office. I don't have a big law firm. I'm sort of part of the indie developers' distributed teams, because often if they're not just a solo, they're working with a team that's working remotely. So I kind of fit in. I think that's pretty cool. Okay, so did we get the chat sorted out? Let's see. I don't know. Well, I'm gonna start answering questions and we'll see how this goes, okay? And even if there's problems, it'll be available on YouTube afterwards. I'll put it up on my website and my blog, so you'll be able to check it out there. So the first question came from a guy named Johnson Turing. He asked, if he's a solo developer, can he sell his game without forming a company or a business? Of course you can. It's not the smartest idea, but if you do, you'd be known as a sole proprietor, which means that you are just sort of naked in the world. You're like a baby in the business world, sort of fending for yourself. Because when you form a separate business entity, you're giving yourself the benefit of what's called limited liability, which means that the business entity is like a separate thing from you. So you're kind of shielding your own personal assets by having this separate business, right? And it's important that the separate business stay very separate. So you have a separate bank account, you do a separate accounting, all of these things. So when you form something like a limited liability company, an LLC, or a corporation, a C Corp or an S Corp, all of those will give you benefits of limiting your personal liability for business problems. So if your business gets sued, if you're a sole proprietor, they're going to sue you personally, which is something you want to avoid by having that separate business entity. A lot of people say, well, you're just a solo developer, you're putting an app on the App Store, what could go wrong? Well, you could either inadvertently or willfully commit copyright infringement, and you get sued for that. You get sued for hundreds of thousands of dollars in damages, and that could be, they could go after your house or some other assets that you have if you're personally liable for that copyright infringement, rather than the corporation or the LLC. Let's say you fail to comply with a DMCA notice where some user uploaded some copyrighted content to your website. Then they could go after you because you would be liable personally if you don't have a separate business entity. Even if you have a contract dispute with one of your contractors, that could lead to a liability personally for the screw up with the contract if the contract isn't between the company and the contractor rather than you personally and the contractor. So that's why generally any lawyer will tell you form a separate business entity if you're going into business. And how do you know you're going into business? Well, if you're selling a product or you're even giving a product away, you're in business. It's sort of the first lesson that very small developers need to learn is that you're going into business and you need to start acting like it. It's very important. All right, so that's question one. So the second one. So John Oda asked quickly about the statute of limitations on joint copyright claims. Generally, for copyright claims, there's a 3-year statute of limitations. I'm not entirely sure what he means by joint claims, but even if there's other parties involved, I don't think that would extend or make the statute of limitations shorter. So that means that from the latest infringement, they have 3 years to bring a copyright lawsuit. There was a Supreme Court case recently where I think the writer of Raging Bull had brought a copyright infringement lawsuit that, even though Raging Bull came out in 1973, they still could bring it because there was continuing infringement all through the years until then. So, that's one of the dangers of copyright infringement. If you keep doing it, then it keeps pushing that statute of limitations. Although they'll only be able to sue you for the things that happened within that last 3 years. So the preceding 20 years or so didn't count in the Raging Bull case, to my knowledge. All right, next question. Jay Walters. As a solo developer, what do I need to do to make sure my EULA is legally valid? The EULA is the end user license agreement. It's that stuff you click past when you go into a mobile app or a piece of software. For example, can I take the terms of use from Angry Birds and just use that and modify it for my own brand or my own game? Also, is it enough to just link to the EULA on my site from the app install page, or do I need to put it in the game so the user has to click accept before playing? All right, these are two big issues here, and these are important. So, well, the first question, you're not going to want to hear this, but it's probably not the best idea to just take Angry Birds and switch the name, Control F and change Angry Birds to your game name. It's not a smart idea because your game could have a lot of other things going on that Angry Birds doesn't, such as maybe you have user-generated content in your game, or your virtual currency system works differently, or any number of things could be different in your game than they are in Angry Birds or whatever game you're taking it from. So I know I have a vested interest in this, but I would always recommend that you get a lawyer to look over your app and draft your terms of service or your end user license agreement, any of that. It's one of those things that should be personalized. It's the same with the privacy policy that you have either on your website or your mobile app. Privacy policies are a big deal, but they need to be personalized, right? You can't just sort of take a generic privacy policy and throw it on there, because how you deal with privacy and all those issues may be different than how Apple uses it, or any other, who knows what the website is that you're taking it from, right? So it's important that it's personalized for your specific game or app or whatever you're doing. So the second part of that question was, where do you need to put the EULA or the terms of service, right? So there's two types of agreements that people have for these websites and for mobile apps. There's something called click wrap agreements, and there's something called browse wrap agreements. So the click wrap agreement is one where, no, let me start with browse wrap agreements. Browse wrap agreements are ones that are just sort of posted on a website, or posted, like he said, in the App Store page, right? You just have a link in there that they have to click, and it's up to them to do it. It's hard in that, and those are sort of frowned on by people like me, because it's a legal agreement. You can't just sort of have it sitting around and expect a court to look at it and say, well, of course they agreed to it, they played the game. But if they never saw the agreement or that it existed, then they would have no idea that the agreement existed, and therefore they didn't agree to it, right? So you can't hold them to it. There were some cases involving Blockbuster Video and their website, and I think one with Netscape, where the link to the thing was like you would have to scroll down in order to see it. So it wasn't obvious that they actually clicked it and agreed to it. So they couldn't enforce the arbitration clause that was in their terms of use. So this is where click wrap agreements come in. And this is what you see most of the time. A browser window will pop up, and it'll have a little checkbox where you have to check that, and then you click agree. And by clicking that, and that's sort of an affirmative action on the part of the user. So that, in general, is probably enough to make it a binding contract between you, right? And that's what the EULA is. It's a license agreement, right? And so, while it seems like no big deal, and especially to the user when they just click through it, like even I do, it seems like it's no big deal. But when there's a problem, then it is a big deal. And that's the whole thing with what people like me do. We try to deal with things assuming there's going to be a problem in the end. And maybe that's why people don't like lawyers. I don't know. All right, next question. Chad Ferries, he asked, are there any new trends and decisions made by courts that have affected game development, since it looks like the number of publishers and developers have increased a lot in the last decade or so? Sure, there's actually a lot of recent video game related court cases. I'm not sure if it's more than before, because there's old ones dealing with Atari and Street Fighter, and I mean, they go back, but probably there's more than ever, just because of the proliferation of the industry, like you said. Recently, I think it was in 2013, the Supreme Court had a case dealing with video games and whether or not they're protected by the First Amendment. And so they held that video games are indeed dramatic works entitled to First Amendment protection, which is kind of novel, and it's a big deal, because that means that because a video game is covered by the First Amendment, you get a lot of other different protections that are First Amendment related that movies and TV shows and books enjoy. So in particular, Electronic Arts has been fighting a few different types of cases over the last few years, such as they wanted to be able to use real-world weapons and helicopters in their games without having to pay a license fee to use that name. And I think they won that on First Amendment grounds. Actually, I'm not sure. I'm going to have to write a blog post about this stuff, because it's hard to keep up with all these cases. The ability to use real depictions of sports figures, football players, I think. There was one where college players sued them and the NCAA, and that's led to a lot of changes, because they're using college players and using their likenesses, but I think and they're claiming that it's a First Amendment issue. I believe they lost that one. And then there was another one against some pro players, where I think former pro players had sued them because they could be used in a different football game. There's also a number of ongoing lawsuits dealing with clone games, from board games to mobile games. There's tons of these lawsuits. How much the courts are dealing with how much of the game rules and the game mechanics can be protected by copyright. Because sort of, in my reading of it, some of the traditional ideas of copyright are that, yes, the art and the writing and all that can be protected, but the actual mechanics and how the game works can't. But there seems to be sort of a blurry line now, where some people are allowing protection for the mechanics themselves, especially when there's some sort of creativity in there. But then again, you have things that are sort of common to the genre that aren't protected. So we'll see how this shakes out. It's pretty interesting. There was a recent case with filed by creators of the Deer Hunter 2014 app. I mean, I talk about these on my blog, so if you want to check it out there. Actually, I don't know how I get that on my lower third, but it's strebeklaw.com, or you can go there by boardgamelawyer.com. Will take you to my website. All right, let's go on to the next question. Josh Wood has a question about copyright law and parody. So he wants to know, can he have a city building game, for instance, with a coffee shop called Starducks or some other sort of parody name? Or what happens if you have a coffee shop in the game with a name, and then you later find out that there's an actual store with that same exact name? Can you get into trouble? I mean, the easy answer is yes, you can always get into trouble. Someone can always sue you for whatever they want. Whether or not they win or not is the question. But it's more of a hassle than anything. So there's two questions here. First, these are more about trademark than copyright, because trademark talks about brand names, and they call them source identifiers, which is like how a consumer buying a product would identify where the thing they're buying is coming from, right? So Starbucks and the logo and all of that are identifiers of that source. That's what the trademark is. So when you go and you see that Starbucks logo on coffee, you know that it's coming from Starbucks. If you see something that's sort of a rip-off of that, it's likely to confuse consumers, and so they don't know, is it coming from Starbucks or is it coming from these guys? And it could ruin, it could, tarnish the brand of Starbucks. And I know, sometimes people laugh at this stuff, but it's true. If you let this stuff go on and everyone's using your name in selling products or like adult toys and things like that, it can make your brand worse. So this is why people are so crazy, especially Starbucks. I remember here in Thailand, there was a guy running a little coffee stall. He called it Starbung or something. I don't even know what that means, but it looked like the Starbucks symbol, and they sued this guy who's basically running, and I've seen these things out there. I mean, it's just a dude running a little cart where he's probably making Nespresso or something like that, and so, or Nescafe, and so they sued that guy. I don't know what happened with that, but things can get pretty serious when you're messing with big brand names. So this is where the problem is. So if you're going to do a parody of the name, and it's going to be close, this defense has to be strong. This is a defense, all right? You don't just claim parody and everything is gone, right? Parody is defense. It's a First Amendment defense to someone suing you for trademark infringement, right? So if you just, if you're just hoping that, you can say, hey, wait, you can't just claim parody and it's okay. You have to actually prove that in court. That's the problem. Okay, so relying on this kind of thing, just like relying on fair use with copyright, it's a problem, because if you don't have the money to actually defend this stuff in court, you're gonna have a problem getting away with it. So let's talk about parody and copyright, or excuse me, parody and trademark. Needs a few requirements. So there has to be a famous trademark, because when you do a parody, people have to recognize that you're doing the parody. So in this case, Starbucks, yes, is a famous trademark. You're only allowed to take just enough of it to evoke that trademark, right? You can't take the whole thing, so you can't do the whole Starbucks logo. You would, take maybe the green circle, right, and do your own thing with it, or something like that. Or like in this one, use star, but use something else afterwards. Maybe Starducks is too much because it's only one letter is changed. You also need to be sort of clever or witty, or you have to make some sort of point in referencing that work. You can't just do it just to do it, and you have to actually be funny. There was a case where, what was it? Mutual of Omaha is an insurance company, and someone created their own line of clothing called Mutant of Omaha, and he got sued by Mutual of Omaha, and he lost because I guess it wasn't funny enough or clever enough to overcome the fact that he was basically taking their trademark. So this is a big problem. Someone like Rockstar Games, when they do Grand Theft Auto, they have parodies everywhere, so they probably have enough money if they were sued to defend that lawsuit. They're huge, but if it's you have to show this in court. So it's probably better not to engage in these kind of things, but if you do, you do it. I'm not going to stop you. So for the second part of the question, let's say you put something in your game and later you find out that it exists. you pretty much have two options, right? You could either contact them and work out some sort of an agreement, like a trademark coexistence agreement or something like that. Or, number two, just hope they never notice. I mean, if it's just one of the buildings in your city building game and Joe's Coffee is just that's pretty generic anyway, but if it's just a small store somewhere in the US, they may never notice it. So look, if a tree falls in the woods and doesn't really make a sound, that's what I always say. You're not necessarily going to get sued. So, Rohit Mohan, excuse me, asked a question about copyright for game titles. So they have a name for their game in mind, but there's another game with the same name out there already, even though they're in different markets. Well, so this is also more of a trademark issue because names and short phrases, like little sayings, aren't usually copyrightable. Because they're so short, there isn't that much creativity to them. You have to really show that they were very creative. So there's a problem there. It's not really copyright. So trademark, again, goes to the, are you likely to confuse consumers as to what it is? And so if the name of the game is the brand, and it is, how close the products are is the test. It's one of the tests. There's 9 factors or so that courts use, and each court uses a different set of factors. It's a huge pain in the butt. But it depends on how close the products are, whether they're using the same marketing channels, whether they're in the same class of products. And so here you're thinking, well, first-person shooter game is totally different than a casual match 3 game. But in the eyes of the trademark courts, they're not going to see it like that. They're going to look, oh, these are 2 video games, or it's a video game and a board game. They're basically the same class of goods, right? So, that's a problem. You have to realize you have to sort of step back from your knowledge about the game industry and really imagine that. Think of how a court would look at it or how the public would look at it. I mean, you're not also talking about a game fan. You're talking about just any member of the public. And if they see 2 games, even if they're totally different types of games with the same name, that's likely to cause confusion. So yeah, that's going to be the problem there. So again, as with all of these legal questions, just don't do it is probably the best answer. People hire lawyers to tell them what the risks are, and sort of I'll tell you, look, there's a huge risk, or there's always going to be a risk, right? So that's never going to change. Okay, is there a chat going? All right, I'm going to go back to the Q&A. So that was all the questions that people asked beforehand. Actually, I have one more. I'm going to actually go over that right now. Somebody emailed me today, and they were asking about single-member LLCs. Hold on, I have to take a drink. This is why I need a guest on, so there's other people to let them talk while I take a drink. All right, so I asked about single-member LLCs and maybe 2-member LLCs, and what's the point? How much protection do you have? And it's a good question because while a lot of states allow single-member LLCs, it's sort of a bigger barrier to getting to limiting liability against yourself. So if you're just one person, to the outside world, it looks like you just formed this for what reason? To limit your liability, right? Specifically to maybe do something bad, right? So you're going to have to really act like a corp or like a company, really keep everything separate. You have to sort of work extra hard when you're a single member LLC than if you have a bunch of people getting together. Because with a bunch of people getting together, it makes more sense that you would want to form some sort of single entity for all of you to do business under. However, if you're just one person, it could more easily look shady. I'm not going to say it does look shady because people form single member LLCs all the time, but I don't think there's a lot of case law about that. So I can't give a great answer about that. Just more that it's of course riskier, and that generally you have to just do a better job of staying compliant with all those. They call them corporate formalities. Okay. All right, I'm going to jump into these questions in the Q&A. That's great. Okay, so Madison D, you asked, what are the general rules for making a derivative game inspired? Okay, making a derivative game inspired by another to avoid infringement. So take the Fallout franchise, for example. Obviously, there are other post-apocalyptic games, but at what point do you become similar enough to worry? Well, it's a good question. So it could be any number of things, to Fallout, right? So you have a post-apocalyptic world, but you start taking the Bonsai Buddy or whatever the Risk computer that they have. I only played Fallout 3 for a little bit. It was not my type of game. you start stealing actual copyright things that have copyright protection. That's a problem. Either you're taking text from the game or something substantially similar. So if you have another like sort of retro-looking boy in your game, that could be a problem. It depends. It really is very. The problem with this stuff is it's very fact specific. So you're really looking at the specific facts, and you really have to analyze it like that, and sort of match it up against cases that already exist. There's also trademark issues. So what if you're using things that it's called trade dress? It's how things look. So like a Coke bottle has a specific shape, right? That's their trade dress, and it's probably protected, right? And the name is the trademark. It's all basically just protecting. You don't want another bottle out there shaped like a Coke bottle, because then you're going to say, hey, people are going to think that that looks like Coke and therefore is Coke or comes from Coke. So that's why they protect that kind of thing. Or how a restaurant looks, right? Or how a game looks. So recently, Cryptozoic Entertainment was sued by the creators of Magic the Gathering, well, the owners of Magic the Gathering, or Wizards of the Coast, sued Cryptozoic over this game called Hex. It's a digital game, but they're suing and saying that their trade dress is being infringed, among other things. And that would be like the look of the cards. So it's not necessarily copyright, like it's been copied, but just that it's been done in such a way that it could confuse consumers when they're looking at the cards. And they think, hey, this looks like Magic the Gathering. It's Magic the Gathering. So those are sort of general rules to avoid infringement. If it's inspired by something else, sometimes you can, in many cases, you can use their name. You can say, look, this was inspired by Fallout, right? And that's okay. It's called a nominative use of their trademark. I actually have a blog post about that on my blog. So I'm going to maybe do a write-up where I'll talk about these kind of things and post links to the different posts. Okay, so Madison, thank you for the question. And also, if you have any follow-up questions, feel free to ask. Wow, there's a bunch of questions in here. Okay. Jay Walters asks, if I choose to hire an artist for my game, what kind of agreement should be drawn up between us, either as a sole proprietor or as an LLC? That's a good question. So if you have an LLC, it'll definitely, you want it to be with the LLC and the contractor, just because of what I mentioned earlier. If there's a problem, you don't want to be on the hook personally. You want it to be through the LLC, And then all those other issues with the single member LLCs come in. It's semi-complicated, but it's really not that complicated. What kind of an agreement? Well, it depends on whether you want them to be an employee. So if you're setting up an employee relationship, or you want them to be an independent contractor. Usually my clients will work with independent contractors only because it's a little easier. There's less overhead. There's no employment laws or labor laws involved. The only issue there is so that the work that they're making, you want to make sure that you own it. So you want the contract to be clear that it's an independent contractor relationship, and that they sort of have control over their work and how they work and their hours, things like that. And then you want to make sure that there's a work for hire clause, which means that under copyright law, if you have an independent contractor or an employee, you can have it be what's called a work for hire. So any work they do, you're the author of it for the purposes of copyright, meaning that you own the copyright and all that. If it's your employee, then it sort of happens automatically. But if it's the independent contractor, you have to have an agreement, a written agreement that says that. So that's important. And then usually there's a backup clause in there that says that in case it's not seen as a work for hire, call it an assignment, right? And they just assign the copyright to you. Okay. David, is that Kerman? Sorry. David Kerman, regarding trademark infringement and parodies in games, how does one actually defend the fact that it was a parody? Well, you would just show, there's a few cases. So there's one with Two Live Crew did a song sort of parodying Roy Orbison's Pretty Woman, Oh Pretty Woman song. And so you would, when you go to court, you would actually make arguments based on old case law precedents and just sort of analogize them to the current case. And that's basically how you do it. I'm not sure how specific you were looking for. It really depends on the actual facts, right? But you would show, look, that we took just enough of this to make it recognizable, but we didn't take everything, things like that. So you just look at the various requirements for it to be a parody, and you say, look, this is why it's witty, or this is why the point we're making, or something like that. Okay. David had another question. Was wondering whether there were possibilities for some arbitrary indie company to claim that a certain character or sprite is very similar to theirs and sue. Not sure if intellectual property applies there or not. Of course. And look, the problem with the whole legal system, I guess, is that, I don't know if this is a problem, it's probably a good thing, but anyone can sue anyone for anything, right? Whether or not you're going to get a lawyer to take up your case is step one, because our ethical rules say that we're not supposed to bring frivolous lawsuits and lawsuits with no basis, and we can get sanctioned, which means that there's fines, and you could get disbarred and have all kinds of other problems. So generally, a lawyer doesn't want to take a meritless case, but we are also sometimes creative with our arguments, so we will find merit where there may not be any, and we will sue you, right? And so if you get sued, you have to defend it. Unfortunately, if you don't show up, then if they can still prove their case, then they could get a default judgment against you, and then come after you. So this is sort of the sad reality of sort of doing business. You're always, whenever you put things out there, you're opening yourself up to the possibility that someone's not going to like what you're doing and sue you. It's just the way it is. But yes, that's definitely an intellectual property issue. Okay, it is 9:08. I have no more questions. Does anyone else have a question? Please feel free to ask, or if you have anything you want to know. Otherwise, I'll end it. But yeah, on the next one, I'd love to have some guests. So it's not just me blabbing. It could be a little more exciting for you, maybe. I'll just give it another minute or two to see if anyone has questions, and then I'll bounce. It's a little after 9 a.m. here, so the workday is just beginning. Well, I hope everyone enjoyed it at least and learned something. But again, and I'll probably stick this into the YouTube page at when I finally put it up. But this is just sort of general legal information. I don't know anything about anyone's specific situation, and that's the thing. If you have a specific fact situation that you need legal help with, call a lawyer. Don't rely on what's on the internet. At the very least, a lot of them will do sort of a free consultation. I know I do. So we'll at least listen to your problem and sort of let you know what your options are, and you can go from there. I would generally tell people what things would charge or things would cost, and they can either decide to go with me or sort of try to deal with it on their own. And that's entirely up to them. Okay, we have one more question. I want to add analytics to my game. What are the rules about this? Is there a general EULA that covers typical non-personally identifiable analytics event tracking? Yeah, so this is usually covered in your privacy policy. I guess you could put it, you can sort of combine the EULA and the privacy policy and put that all together. But generally, yes, by law, if you're going to release your product in California, in the EU, there's different law, and this is one of the problems with this, is that each territory has their own specific requirements. But generally, if you go with the strongest requirements, you're going to be taken care of sort of everywhere else. But yeah, you need to just disclose it. I mean, as long as you're disclosing what you're doing, are you selling things to third parties? Or are you using, aggregated data, personal identifiable information? The other problem is if your game is targeting, or even if it's not specifically targeting children 13 and under, but if it's a game that looks cute or has cartoons or something like that, it could be seen to be targeting children. So you need to make sure that it complies with something called COPPA, which is the Children's Online Privacy Protection Act. And then there's maybe a California version too. I mean, I'm sure every state has their version, but that's a federal law, and you can get in trouble with the feds if you're not following COPPA. And COPPA requires a bunch of, luckily there are services that will, sorry, I'm reading the next question. So there are services that will handle your COPPA things. Like basically a parent, you need to give a parent the ability to opt out of their child putting personal information up there, or the ability to delete the information, things like that. And actually, California just passed a law where if people put, information on, let's say, Facebook or something like that, or if you have some sort of social features in your game or app, they have to be able to take it off and have some sort of method for easily doing that, and then you have to actually explain the method to them. For, I think, minors, maybe people under 18. I'd have to go back and look. All right. We have one more question. Is there an email address, a blog, or a forum that we could submit questions to you in advance of the next Hangout? Yes, absolutely. Go to boardgamelawyer.com or strebeklaw.com. That's my website. You can always fill out a contact form there and submit your question. You can email it. You can make it as long as you want. The longer is probably worse because you're getting more specific, and that's sort of what we should shy away from. But yeah, definitely send questions for the next one. If you have any questions sort of about general games business things too, I would, I'm hoping to get some more game business type people to get in here and answer some questions. So yeah, absolutely. Please send me an email, and thank you to those who said thank you. And I guess we're gonna end it here. It's been great. I actually had a pretty good time. So next time, hopefully I'll have someone to talk to. This is new, all this Hangout business, so this is pretty cool. All right, guys, thank you for watching. And yeah, this will go up on YouTube. I'll embed the link in my blog, strebeklaw.com. Hold on, let me actually, I'm gonna write it down in here. No one used the chat, so, and I can't ask a question, so let me, hold on. Screen share. Bear with me here. This is, I have no idea what I'm doing. Okay. It didn't come up. Change my lower third. And that didn't work either. What? There it is. Oh, whoa, it's everywhere. Okay. Well, there is my website twice. So go there and you'll be able to find me. Let's flip that on off. That's what I wanted. Okay, I don't know why that wasn't working the whole time. But yeah, go to that website, go to the blog, or excuse me, go to the contact page and send me a message. And all right, I'll see you guys next time, maybe either in 2 weeks, but I will be tweeting and all that about it. So awesome. Thank you for coming.